Yeah, I'm Kenny Caldwell, Associate Director at Quick Gold Unlimited. We are construction and procurement advisors to the construction industry, be that employers, contractors or lower tiered subcontractors. We give advice from contract negotiation right through the contractual process to the end in resolving disputes by way of arbitration, adjudication or whatever form is necessary. Well, what I believe to be some of the main considerations would be how do we make this long term? So, Northern Ireland companies going across the GB to invest themselves and invest their companies in the GB market need to be thinking how we make this last. What plays into that is probably getting a mindset correct and understanding the environment that they're going into, understanding the contracts that they're entering into and how they work with a view to making that sustainable. So top tips probably for avoiding pitfalls on a contractual basis is simply put, know your contract. That starts at the very start of contract negotiation in understanding what you are contracted to do or what you're not contracted to do. Be aware of the payment terms and the reliance that you can place on the law, the legal aspects of the contract. When it comes to variations, etc., know what you have to do to get entitlement, be that by way of notifications, notifying the correct parties, notifying them at the correct time, and be conscious of hidden slip-ups or hidden pitfalls by way of conditions precedent, time bars, etc., that might deny you your right. Company be aware of to help them get paid on time? Well, there are rights for every company entering into a construction contract. A lot of people might not necessarily know that, but there is the law underpinning construction contracts by way of the Housing Grants Construction and Regeneration Act as amended. This has been seen or has been introduced or prophesised as being a lifeblood of the subbie for maintaining cash flow. With it comes certain rights in relation to payment. So a quick read over that, or at least some kind of training on it in relation to the importance of payment notices, getting your applications right and serving the notices should help facilitate payment coming through. Probably goes back to knowing your contract at the start again, knowing what the procedures are in place, being able to identify what the cause of the event was, what the effect of the event is going to be on the contract or contract delivery. Who do we have to notify? When do we have to notify? What is it required by way of supporting documents or evidence to justify or warrant the change? Get it out there early, get it out there often, and hopefully you're not hit at the very end with a large amalgamation of unknowns or global style type claims.